We have a quorum, so I call to order this meeting, and I thank members for attending the meeting. We have a special meeting today to deal with some of the items for the regular meeting in December, including a brief report by Financial Secretary on the overall economic situation of Hong Kong, and also consultation on the budget 2017-2018. And these two items will be discussed at the regular meeting on the 3rd of January 2017. So let's start with consultation on measures to counter base erosion and profit sharing. Let's invite the administration in. So let me invite the administration to walk us through the consultation paper, please. Please be succinct, within 5 minutes, please. Thank you, Chairman, members, and I thank the Secretariat and the Council for arranging for this meeting for us to go through the paper with you. The FSTB has come up with some BPS measures in the consultation document to tie in with OECD's requirements. The consultation period would end at the end of this month, and we'd like to seek members' views on this consultation paper. So let me give you some background on why we need to conduct this consultation exercise. The Organization for Economic Cooperation and Development, OECD, has been striving to combat tax avoidance and tax evasion. And our effort is to tie in with the OECD's initiatives. Every year, tax evasion amounts to $100 billion US, or 240 billion Hong Kong dollars. So a platform is needed. And last year, the OECD released a package of 15 action plans to tackle base erosion and profit sharing, BEPS, with the endorsement of the Group of 20 to tackle the BEPS by multinational enterprises, MNEs. And in June this year, Hong Kong joined this inclusive framework so as to align ourselves with the international standards. So this consultation document contains some minimum standards that tally with the action plans. As for our proposals and measures, they are in chapters 3 to 6 of the consultation paper, and that includes transfer pricing, the regulatory regime. Because in relation to the transfer pricing arrangement for associated enterprises, tax revenue may be affected, and different jurisdictions may have different tax systems. For high profit items, some enterprises may wish to transfer the profit to low tax regions to avoid tax. So we would adopt this basic principle called the arm's length principle in setting transfer price. And this is the internationally agreed standard, and this is not something new. In fact, in the administrative guidelines, the industry has been adopting this same principle. We just want to provide a more solid foundation on this matter. And on tax reporting by multinational enterprises in the future, exchange of tax information between jurisdictions may be necessary. And in this regard, we will also require MNEs to provide local reporting. And we understand that the compliance costs may be high. So some of the associated enterprises would be exempted from preparing these reports.
There are 3 exemption criteria. If, say, the revenue, assets, and the number of employees do not exceed a certain limit, then they do not have to provide such reports. So this is in line with international requirement. And also, lastly, we would like to join the multilateral agreements. And we will do it by way of a MI, multilateral instrument, so that we can make modifications to our agreements with other jurisdictions. Now, this is a consultation paper to tie in with the work of the OECD, and we're part of the international community, so we are discharging our obligations as a member. And we do not plan to add new tax provisions or increase tax at all. So we just want to tackle tax evasion. And also, for OECD, well, we don't have any other choice. Hong Kong must completely follow the timetable set by the OECD in order to meet with the international standards. And for the OECD, there are 91 jurisdictions which have joined this BEPS exercise, including major economic entities, EU, US, the mainland, Macau, and Hong Kong. And for the EU, earlier on, last month, they have come up with some policy papers, and which said that if in the future certain jurisdictions or economic entities cannot come up with timely measures to tackle BEPS, then there will be sanctions from EU members. So in order to protect Hong Kong's economic interest and uphold Hong Kong's status as an international financial center, we must meet with the international standards and implement such measures. So much for my presentation. We welcome members' questions. On the consultation paper, if members would like to speak, please raise your hand. Mr. Chan Kim Po, Mrs. Regina Yip, and Mr. Charles Mok. Anyone else? And the Deputy Chairman? 5 members, 5 minutes. Mr. Chan Kim Po. Thank you, Chairman. Hong Kong is an international financial center. We are obliged to meet with international tax requirements. So, using this legal framework to tackle BEPS, well, I support that. My question is, the agreement here seeks to combat activities whereby the profits will be shifted to low tax regime. Hong Kong is practices a low tax regime. Would we be target of the combat activities? Would there be any impact on Hong Kong? And do we have enough manpower at the IRD to deal with such efforts, and would also be providing support to the enterprises affected? Third, the consultation paper says that 150 enterprises in Hong Kong have to provide CBC report. And what about the number required to provide master file and local files? Thank you, Chairman. Thank you, Mr. Chan, for your question and support. Impact on Hong Kong's tax regime and tax revenue. Well, basically, there should be no impact. Hong Kong has a special tax regime. We have a territorial-based regime. So if enterprises earn profits in another jurisdiction, that should not affect Hong Kong's tax base. But then for overseas jurisdictions or authorities, they might have to exchange information with us. Second, manpower at the IRD. Of course, we have a tight manpower situation. Thank you for your understanding. In the past few years, in relation to tackling tax evasion, there have been a lot of measures mooted. Well, at the end of the last legislative session, I thank members for passing the legislation in relation to TIEA, Tax Information Exchange Agreements, and now we are having new measures on BEPS, and of course would add to the workload of IRD. Once we've got the concrete measures that need to be put into place, then we will make an estimate of the extra manpower needed, and then we will make application for funding correspondingly. Now, with regard to master files and also local files, how many enterprises are required to do that? Well, it depends on how the exemption will work out ultimately. There are 3 exemptions situations. In the past couple of months, we met with the trade, and they have given us views, and they asked that the criteria be further relaxed. The number of enterprises to be affected, well, that our suggestions or our discussions will have an impact on that. We don't have any study on the asset situation of Hong Kong companies. We do have certain information on revenue, but not assets. So at this stage, we might have not an accurate estimate on the number of companies which have to provide such files. Support for affected enterprises. In terms of support, we want to try to simplify our requirements as much as possible. And if they have to submit master files, we would hope to provide some templates for them. Any follow-up? No. Okay. Next one, Mrs. Regina Yip. Thank you, Chairman. OECD is very much a research organization, a big think tank. Hong Kong is not a member. Our sovereign state is a member. We are just a member of the subcommittee. Do we necessarily have to join it? G20, I know that they have a lot of suggestions which have been adopted by the financial authorities of various jurisdictions. Is it because the G20 have endorsed it, and then that's why we have to join this? Is the mainland, is China implementing similar measures? And what about Singapore, our competitor? How are they implementing these measures? Many people told me that that the compliance cost is very high, and the clients have complained. A bank even told me that they are not going to have business dealings with multinational enterprises and also dual resident entity and so on. How is the Singapore situation like? Maybe they are called regulatory arbitrage, and then we will be losing our business to others. Thank you, Mrs. Yip, for your question. OECD has come up with a 15-inch action plan is endorsed by the group of 20. And also it's been supported by the EU. So major economic entities and governments worldwide have given full support to the suggestion. At the early this month, 91 jurisdictions have joined this BEPS framework. Let me cite an example. In early November, EU has come up with a policy paper which has been endorsed by the European Council. This BEPS has become a priority work area for them. And for international centers and also developed economies, if they are working too slowly and they cannot meet with the OECD timetable or they can't implement the measures effectively, the EU member states will consider them as uncooperative tax regimes, and then sanctions will be imposed. So given that this is the case, there is a need for us to avoid being labeled as an uncooperative tax jurisdiction. And in fact, China and Macau have joined the BEPS action plan. And this BEPS is open for participation by sovereign states and also their subsidiary or member states. With regard to higher compliance scores and more information required on the part of the clients, And this has something to do with the TIEA endorsed by the LegCo in June. And for TIEA, it's also there to meet with the international standards drawn up by the OECD. So it just doesn't apply to Hong Kong only. Other jurisdictions have to follow as well. Follow up. We all know the background to these policies. The advanced economies are worried that MNEs will avoid taxation by using low tax regime, and so we don't have to compare ourselves with Japan and Singapore. And maybe our competitors are not following the rules, and they will be snatching the business away from us. Well, we are always very law-abiding, Hong Kong, isn't that the case? Let me ask Mr. Chiu to take that question. Thank you, Chairman. Let me add. For Singapore, we are watching closely their work. Objectively speaking, I think their progress is more or less on a par with us. And for some areas, they are moving faster even. I must emphasize one point. For BAPS, it has been endorsed by the Group of 20. And the EU would also come up with a list of uncooperative tax regulatory regime. Well, if one is labeled as such, then the EU will impose an additional tax on any money transferred or transmitted to such a jurisdiction. So this is a very pressing task for us, and we must implement BAPS. Will operating costs of enterprises get higher? Yes, there will be some sort of impact in that regard. But this is something which has been accepted internationally. In terms of competitiveness, I don't think Hong Kong's competitive edge will be eroded vis-à-vis Singapore's competitive edge. Mr. Charles Mok, on Monday, I talked to some people from the business sector. The Vice Chairman was also there. We talk about jurisdictions like Ireland. The economy there has developed fast in the past 2 years, and one of the reasons is because, well, it is one of the area targeted under such policies has become a tax haven, and the EU will crack down on the practice one day. We should not be just focusing on the impact on, say, the banking industry, the finance industry, and Mr. Zips was mentioning that one bank will not do business in that area. But I would say that on the reverse, there will be if we are a tax haven, then we will get more business. But then, well, tax regime are very connected worldwide, and how can we make the best use of the regime? Ireland is part of the EU unless it exits from EU. I don't know whether, say, companies like Apple, whether they will go to. Let's think about the economic development of Hong Kong as a whole. Mr. Chan mentioned about high tax regime and low tax regime. We're having a low tax regime, so we're not to benefit from such measures. But then we are not a regime with the lowest tax regime. And also there are also value-added tax imposed by some jurisdictions. In Hong Kong, we don't have value-added tax. So what I'm concerned about is whether we are being too conservative. We just follow what is asked or required of us by the international community. Are we being too conservative? Well, it's not that we should not follow what the international community asks us to, or whether we should think of something more.
Perhaps we can be the so-called bad boy and attract more business to come to Hong Kong. So maybe it's a policy direction. Can we just follow 80% of the rules and attract businesses to come to Hong Kong? It's just like what Donald Trump is doing. Why not think out of the box for the sake of the overall economic development of Hong Kong? Don't just do the biddings of international organizations, because after all, it's the G20 countries that are most related. We totally understand Mr. Charles Mock's thinking. Now, on this occasion, to align our standards with the OECD BEPS measures, we are only meeting the minimum requirements because the OECD has a package of 15 action plans, out of which 4 or 5 action plans should be implemented by all countries. And what we're doing is to meet the minimum standards. And if we can't do that, the G20 or the European Union might perceive us as the uncooperative tax jurisdiction, and it may have a negative impact on us. We're not trying to outdo Western countries. We're only trying to meet the minimum standards. Now, on digital economy and globalization, what policies does the government have to attract more businesses to come to Hong Kong? I think colleagues from the Invest Hong Kong and CEDB have been working in this direction. And yet we need to be careful because the OECD and the EU do have a stance on combating BEPS and tax evasion. They have been attaching importance to this in recent years, and therefore we must consider our tax policies in the light of the latest international developments. Mrs. Regina Yip, 4 minutes. A very brief one, Chairman. I hope that the Permanent Secretary can supplement on this point of fact. We're not a member of the OECD. I attended those meetings before, and Hong Kong is only an observer in relation to certain committees. I believe at the moment we are an observer of the Financial Committee. We have a lot of experts from Hong Kong attending those meetings. Of course, we support government officials in Hong Kong to attend the committee meetings or expert meetings of the OECD, and we even plan to set up an office in Paris. We hope to exert certain influence in their decision making, so that we can be on par with our competitors like Singapore. So the question is, which committees have we been acting as an observer? Now we are taking part in the ad hoc group under the Multilateral Instruments Initiative. The other one is the inclusive framework of BEPS. Again, Hong Kong has joined the framework. Now, the wording that I use is participation or joining the framework. That means we only join on invitation. And we have another
Global Forum， 香港都係一個成員嘅。就稅務呢方面
Forum on Tax Administration, and another one. Hong Kong has joined these 4 groups or committees. Thank you for the supplement, because as I remember, as many as 20 years ago, we strived to join, a number of committees such as trade and financial committees. So in formulating policies in the future, I hope the government officials attending meetings in Paris would strive to protect the interests of Hong Kong people. Dr. Kenneth Lau. Other members already asked whether we need to strictly comply with the OECD requirements. I'm looking at the annex. Well, there are 15 action plans, And my question is this. Regarding the bill to be tabled, the objective would be to implement certain action plans, and according to you, you are going to abide by the minimum or basic standards. But after that, are you going to implement the rest of the 15 action plans? Second question. What is your proposed timetable? So just these two questions. P.S. Thank you, Chairman. Thank you, Deputy Chair, for the questions. Among the 15 action plans, according to the OECD requirements, we at the moment will meet the 4 minimum standards, including transfer pricing in Action Plan 8 to 10, and also exchange of tax information. That's Action 6, and also CBC reporting requirement, Action 13, and cross-border dispute resolution mechanism, Action 14. And these are the minimum standards of BEPS package that the OECD would like the other jurisdictions to comply with as soon as possible. And it's true that in recent years, in dealing with the OECD, our observation is that they have been implementing more and more requirements, and we cannot therefore rule out this possibility that the OECD may be setting a timetable for other action plans for implementation by other jurisdictions in future. So definitely we can envisage a stricter compliance in the future. But at this moment, our work is to consult the relevant sectors and to prepare legislative exercise. So we can only meet the minimum requirements at this moment. What about the timetable? We're in the process of consulting the public. We hope that by early next year we can amend our implementation strategy, and then later next year we can table the bill into the Council. Next, well, can I just ask a follow-up question first? Yes, just one. According to the discussion paper, in paragraph 8, for country-by-country reporting or CBC reporting, for enterprises having transactions with the associated entities, then if one of the criteria in 8A 123 is met, then exemption can be given. Does it mean that some enterprises can make use of this exemption? Say, for example, no more than 100 employees in 8A3. I think this can be met very easily. I hope the authority would take a lax approach. And I'd like to know your position in including these exemption criteria in your bill. P.S. Thank you, Dr. Leung, for your question. In paragraph 8A of our paper, we have set out the exemption criteria. We'd like to be pragmatic, and we also like to make it we would also like to facilitate enterprises business. First of all, if transactions are carried out with non-associated enterprises, there is no need to prepare those master and local files. Whereas for transactions with associated enterprises, we set out in 8A the 3 exemption criteria. And if the enterprise can satisfy 2 of the 3 conditions, then there is no need to submit or prepare the files. And we believe that this is already quite relaxed approach. And we are actively considering the suggestion from the sector, whether we can further relax the 3 criteria. And yet there must be some form of control. Mr. Leung Kwok-hong. Thank you, Chairman. Good morning. I think today you should answer my questions. There are 3 proposals. There are 3 exemptions. Say for enterprises with total annual revenue not more than $100 Hong Kong million, total assets not more than $100 million, and no more than 100 employees. So do you have an estimate how many enterprises would be involved? That is, citing the 3 exemption criteria in the paper. Not more than 100 million Hong Kong dollars total annual revenue, not more than 100 million dollars total assets, and not more than 100 employees. Do you have an estimate? Now, to reply to Mr. Leung Kwok-hong's question, the IRD has an understanding of the tax revenue from enterprises. On the number of employees, again, we do have an understanding, but we have a void here. We may not have a clear understanding of the total assets of enterprises, and that's a difficulty for us. However, the exemption applies if they satisfy 2 of the 3 conditions. Well, let's say if you have no idea about the assets of enterprises, and it is only natural because they would come up with corresponding strategies such as setting up another enterprise, but you may be able to gauge the annual revenue from the tax, from the profit tax that enterprises pay, and also no more than 100 employees. I think you should have an idea about that, because businessmen, they're cunning. They can just set up another enterprise to transfer the assets. Perhaps after the meeting I can provide members with the figures on the number of enterprises with not more than 100 employees in Hong Kong, and the number of enterprises with total annual revenue not more than $100 million. And the information comes from different systems within the government. But indeed, we do not have an objective assessment of the total assets of enterprises. Right, we all understand that there are ways to manipulate the assets. Another point is that we also rely on to rely on the various agreements as a basis for automatic exchange of CBC reports with our partners on a bilateral basis. So I wonder if 1 country, 2 systems apply. I understand Mr. Leung Kwok-hong's question. For the CBC reports, that's the term used in the OECD report, country-by-country reporting. As for BEPS measures, they include sovereign states as well as tax regions. So it's not really country per se. Hong Kong and Macau is also part of the framework. And let me read this again. Automatic exchange of CBC reports with our CDTA and TIA partners on a bilateral basis. So how about Macau and the mainland as our partners for automatic exchange on a bilateral basis? Because we're not a sovereign state. I'll try to take Mr. Leung's question. At present, between Hong Kong and the mainland, we have a comprehensive taxation arrangement, or CDTA, that allows automatic exchange of tax information with the mainland. So if we go through further formalities in the future, we can exchange CBC reports with the tax authorities in the mainland. It's a question of should or may. If we say that we should, Then for MNEs with annual consolidated group revenue equal to 6.8 billion Hong Kong dollars, CBC reporting will be required. So comparing, in relation to the mainland and Macau as partners, I want to know whether they are partners for automatic exchange.
Hong Kong and Macau do not have a tax agreement with each other. So for the time being, we can't exchange tax information. Well, so that's your answer. Hong Kong and Macau don't have it now. But after the CBC report requirement is implemented, I don't know what would happen. Will that report be have to be filed, say, by a sovereign state or what? Automatic exchange of CBC reports. The China is a PRC, and we are a special administrative region. So if an enterprise has an annual consolidated group revenue of over $6.8 billion, then the CBC report has to be filed with us, and then we have to exchange it with the other jurisdictions or what? Yes. They have to submit the report to Hong Kong. Well, mainland and Hong Kong have two different tax jurisdictions. According to our arrangement, we can exchange tax information. So I accept your answer. That's okay. Mr. Wu Chi-wai, my question is simple. I would like to understand that when the information or after the information has been exchanged, will there be any disclosure mechanism, or will it be just kept within the tax authorities of the jurisdictions, and there will be something for internal reference only? Thank you, Chairman. According to the tax agreement, the information exchanged can only be used for tax purpose, unless there is anything, any other condition prescribed otherwise. Hong Kong has signed many tax agreements with other jurisdictions, but then we are not allowing the information to be used for non-tax purpose. So, put simply, all the information can only be used for tax purposes. Let me cite a specific example. Disneyland is a U.S. listed company. I don't know whether I get it right or not. In accordance with the established mechanism, Hong Kong's operation information has to be handed back to the U.S. headquarters and the U.S. authorities. So, if information is exchanged, well, the information of the U.S. headquarters or the report compiled it be affected in any way. The OECD has set requirements on the reports or the use of the report. It can only be used for risk assessment. And no levying of tax should be done based on the report. And as to how the U.S. tax authorities will use the information, there are certain constraints, I believe, but then I can't really give you the details. I can't speak on their behalf. Now, when we scrutinize the bill, well, the measure affects jurisdictions worldwide, so we would be able to understand how the different tax authorities in different countries will use the information exchanged. OECD has a review mechanism, and some expert groups will come to Hong Kong and other jurisdictions to see how each tax jurisdiction implements the OECD's requirement and the treaty, including whether the information is used for the designated uses and no other use, and also whether your legal framework is robust enough to implement the OECD requirements. They will also look at the computer system, whether sufficient security measures have been put in place and there will not be any leakage of information. So there will be certain standards imposed. It's not that every tax jurisdiction can freely drop their own criteria. They have to abide by the international standards. So the international standards will apply to each tax jurisdiction. Is that the case? Yes. If they have got tax information from another jurisdiction, they can only use it for tax assessment purposes. Well, I'm talking about the CBC report. The CBC report can only be used for risk assessment purpose, not even for levying of tax. If they have to further decide whether further tax has to be levied, then they have to do further investigation. So in other words, that would become, well, the tax authority has to use their own or through their own tax legislation in order to further levy tax. They can do it. They cannot do it just on the basis of the CBC report. Now, if we have further discussion on the matter, can we be given more information on what is allowed to be done by the different tax authorities? According to past experience, OECD will compile reports on individual tax jurisdiction. Now, in relation to BAPS, I believe that OECD will do something similar, compile a report on each jurisdiction, and from those reports we will be able to ascertain whether the international standards are being implemented by the different jurisdictions. We've spent 50 minutes on this matter. Then two other members would like to speak. Mr. Charles Mok and Nan Kwang Ha, I'll draw a line here, 4 minutes. Mr. Holden Chow to 3 members. Mr. Holden Chow, because it's the first time that you speak. Thank you, Chairman. Just now, we refer to the 3 conditions to be met, and they are on the exemption, total revenue not more than $100 million, total assets not more than $100 million, and no more than 100 employees. These are to ensure that the SMEs do not have to shoulder heavy compliance costs. I would like to follow up on what others have said. There is a automatic exchange of information or exchange of CBC reports. When the exchanged information is at the hand of another jurisdiction, do we have any measure to ensure that such information is only used for risk monitoring purpose? You said that they should not be using such information to further levy tax. It's just for risk assessment purpose. So how can we make sure that this is really the case? You have to appreciate that there is a lot of confidential information in such reports. Thank you, Mr. Holden Chow, for your question. The OECD has a 3-tier report system: master file, local file, and CBC report. If Hong Kong enterprises cannot meet the exemption conditions, and they have to provide master files and local files, and these are managed by the IRD only. In terms of the CBC report, they have to be provided by MNEs with group revenue exceeding euro $750 million. Then if the BEPS come into force, then such CBC reports have to be exchanged among different jurisdictions. These reports provide basic information only. OECD has also certain indications on the content of the CBC report. The MNEs, if they operate in different jurisdictions, have to provide information on the revenue, profit, tax, payment, number of employees, fixed assets, and capitals, and so on. So this is just basic information to enable tax authorities have a better understanding on the operation of MNEs. And as what Mr. Chu said, if they want to follow up further on MNEs, they have to go by their own local legislation to further follow up with the MNEs. Any follow-up? Can I ask one further question? If going by what you said, you are just talking about basic information. Well, MNEs are very likely listed companies, and the basic information should have already been made public. So what is the scope of such basic information? If it is so basic, it has already been disclosed and made public, and they don't have to. I mean, such a system doesn't mean a lot, right? Thank you, Mr. Chow, for your question. I agree to a certain extent of what he said. To listed companies in particular, the CPC reports, the information in CPC reports were already been covered by the annual reports of these companies. Mr. Chow asked, how can we ensure that the tax authorities will discharge its duties duly? Well, it has to do with the agreement signed among different jurisdictions, how these authorities are implementing them. This is not something new. So if they breach the treaty, we can stop exchanging information or even terminate the agreement altogether. So these are the things that we can do. Well, we have a tight schedule. So second round, 4 minutes, including questions and answers. Mr. Lam Kwok Hong. We envisage that about 150 enterprises will be caught by the above criteria, i.e. to follow the suggestion. A revenue of over $6.8 billion. Have you done any analysis on these 150 enterprises? Which sectors are they in, mainly? And how did you come up with this number? Of course, you say that you will go by the tax information, right? And you will also be including corresponding penalty provisions in the IRO. Have you got any thoughts on the penalty? Would you be adopting the same approach as that in the IRD now? If you impose too light a penalty, then it won't affect the enterprises too much, and they would very gladly pay penalty. And we're talking about a revenue of $6.8 billion. Say, if you just fine them $20 million, then they would just regard it as part of their cost, and they wouldn't care about your regulation. I believe that under the present IRO, the penalties will not be too heavy, right? And if the penalty is too light on our part, whereas the penalty on the other jurisdictions is heavy, then many people will come to do business in Hong Kong because of our lighter penalty. But then there is another question. Well, our enterprises will lose out. If there are differences in the penalties, then that's going to be a problem. Well, people will not care about the regulations if the penalty is too light. But for enterprises, then if they go to other jurisdictions, they will be meted out a heavy penalty. We envisage that there are 150 MNEs which have to be submit CPC reports. On penalty, if we are to comply with the OECD requirement, we have to ask Hong Kong companies to provide extra information to the IRD.
We need to make sure that the information must be submitted to it in a timely manner, and the information must be accurate, and a penalty system therefore must be necessary. And in preparing the penalty provisions, again, we are not starting from scratch. For incorrect tax returns or tax return with misleading information, we already have the relevant penalties, and we're going to draw reference from these penalty provisions. So, under this framework of the IRO, this is my point. I want you to put on the thinking cap and consider whether we have sufficient deterrence in our penalty provisions. Because if it's only financial penalty, if no imprisonment is involved, then it's just like illegal parking. A driver may just park illegally anywhere in the street by paying just several $100s. Just like some police officers said, it's the parking space for the rich. They can just park several hours in the street for several $100s. So definitely, if the penalties are too light, you will see this happen. Just a very brief reply, please. We're out of time. Well, definitely, our tax laws may be different from other jurisdictions, but under the current IRO, depending on the severity of the situation and the breach, we do have the penalty of a fine as well as imprisonment. Mr. Charles Mock, thank you. Last round, when the administration answered my question, they said that they are only adopting the minimum standard. And I can't help but think of this. We have a unique position in the world. We have a low tax regime. We have a simple tax regime, as we often say. So we could become the island of Asia or island of China. Just now you mentioned about the big countries in G20, and we may be penalized if we don't follow them. But wouldn't our country protect us by saying, say, the Hong Kong SAR is a special region in mainland China, or even the special region in Asia, and if anything happens, then the mainland can act as our shield? Can this be done so that Hong Kong can enjoy this special status, so that our economy can be boosted in this manner? Well, will the central authorities protect us? Right, perhaps the PS should persuade them as well. Thank you, Mr. Charles Mock, for the question. In implementing the latest OECD requirements, we definitely would like to maintain our position as a low-tax state with a favorable business environment. And we're not positioning ourselves as the tax haven. This is not our objective, because it is perceived quite negatively. So we'll continue to implement these international obligations. Well, not necessarily a tax haven. I'm not referring to those islands. But I gave you one example just now. Ireland, for example, provides some preferential treatment. So I want to know whether we can have a special financial position around the world on tax matters. Under the basic law, we have a separate tax system from the mainland. We can have our own tax laws and our own tax system, and we abide by our taxation principles in participating in international activities. I think we have had an ample discussion on the consultation. If there are no objection, let's move on to the next item. Next item. And proposed enhancements to the position limit regime in Hong Kong. Let's invite the SFC representatives in.
Now
we're going to discuss the legislative proposal to enhance the position limit regime in Hong Kong. So would the administration please walk us through the proposal? Thank you, Chairman. I'll defer to my colleague, Mr. Leung, to walk members through the paper. Thank you, Chairman. At present, under the SFO, we have relevant prescribed position limits and also for future and options contracts. And no one should hold the position exceeding the prescribed position limits in the law. The advantage of setting position limits is to prevent the build-up of large positions that may affect the orderly functioning of Hong Kong's financial market. But at the same time, we understand the impact of position limits in the market development. So we have reviewed the position limit regime, and in recent years there have been rapid developments and expansion of the market, and we have therefore reviewed the position limit regime. In September this year, the SFC published a consultation paper to propose enhancing the position limit regime, and there are 5 proposals. I'll go through them succinctly one by one. The first one is that under the SFO, the SFC can authorize an exchange participant or its affiliates to hold or control a specified contract that is any of the HSI or Hang Seng Index and Hang Seng China Enterprises Index, HSI futures and options contract in excess of the prescribed limits by up to 50%. And the excess position limit so authorized may only be used for hedging purpose. The measure was introduced in 2007. It has not been a very popular measure. According to the sector, some market participants explain that the maximum cap on the excess limit of 50% is not large enough vis-à-vis the size of their business activities, and that they would instead rely on OTC derivatives for hedging. And they therefore would not use this tool for hedging. To encourage the transactions, more transactions to be carried out in the exchange market than OTC markets, we propose to raise the cap on excess position limit from 50% to 300%. At the same time, to reduce risk, we are also going to raise the asset requirement from not less than 2 billion Hong Kong dollars to not less than 5 billion dollars. That's for net asset value requirement. And we can also require some market makers to hold or control futures and options contracts in excess of the prescribed limits, but at the moment it does not cover ETF market makers. Because at the time when the measure was introduced, the ETF market was still developing, but over the past decade, the ETF market has been developing rapidly, and we therefore believe that the ETF market makers should also be covered. The third proposal has to do with index arbitrage activity. Some members may understand the importance of index arbitrage activity in the market, because through this trading strategy, the price of stock index derivatives can be brought back to closer to the market level. So it's a useful hedging tool because of the benefits as mentioned and because of the views received. The SFC proposes that for participants and their affiliates, they should also be eligible to apply for authorization to hold or control HSI and HHI futures and options contracts in excess of their prescribed limits to up to 300% of the prescribed limits. Again, to reduce risk, we do have some financial capability requirement, and we also need the EPs to have effective internal control procedures and risk management systems. The fourth proposal has to do with asset management or asset managers. Under the existing limit, contract limit and report position rules, an asset manager who has a mandate to buy and sell futures and options contracts for funds under his management is required to aggregate all the positions of each fund for the purpose of compliance with the limits. So the existing prescribed limits may be too restrictive. Our proposal is that the SFC may authorize asset managers to hold or control HSI and HHI futures and options contracts in excess of the prescribed limits by 300%. And we also will be implementing some requirements. For example, the asset manager must be licensed for Type 9 regulated activity under the SFO, and its total value of assets under management (AUM) should be no less than $100 billion. Because if the size of assets is too low, there shouldn't be a need to apply for excess of the prescribed limit. The last proposal has to do with the stock options contracts position limit. According to the consultation paper released earlier, the Hong Kong Exchange proposal is to raise the position limit model, and the proposal is supported by the market, and we have assessed the risk. The risk is relatively low. At the same time, we also like to encourage development of the stocks and futures contracts in Hong Kong, market in Hong Kong, and we therefore would propose a higher position limit of 100,000 and 150,000 contracts. We received altogether 10 submissions at the end of the consultation period on the 21st of November. In general, the submissions support our proposal, and we also have some submissions urging us to lower the limit. And we expect that the consultation conclusions can be issued in the first quarter of 2017, and then we will table legislative amendments to the LegCo for scrutiny by members. Any member wishing to speak on this legislative proposal? Mrs. Regina Ip and Deputy Chairman. Four minutes. I don't need 4 minutes. Thank you, Chairman. I have not received any objection from the sector. I just want to know how many enterprises would be eligible under the proposed enhancements to the regime because you have quite a high asset value requirement. Now, comparing to New York, London and Singapore, the three other international financial centers, I want to know by adopting these measures whether we are getting ahead or lagging behind.
How many companies will be affected? We estimate that it is mainly the international companies who would benefit from the regime. We now have a position limit. For example, HSI, 10,000 contracts, HI, 12,000 contracts. So the total value amounts to over $1 billion. So for the small operators, they should sufficient. It's really meant for the big operators. Now, a comparison among the different international centers, each center has its own uniqueness. In Hong Kong, we introduced this position limit in response to what happened at the Asian financial crisis. And Hong Kong is comparatively restrictive compared to other international financial centers. But then after years of development, I think we should be relaxing the requirements step by step so that more development can be allowed in the market in Hong Kong. Thank you for your reply. So can the administration provide a paper later to tell us how Hong Kong compares to, say, London, New York, and Singapore in terms of the position limit for reference? Mr. Lui, can you provide that information? Second one, Mr. Kenneth Lang, Deputy Chairman. I have some basic questions. We talk about futures and options market position limit. Are we talking about underlying equities for hedging purposes? Are these the limits on these? Underlying equities position limit. The present position limit does not refer to the underlying equities. It refers to the number of contracts, futures and options contracts that you hold. Wow, that's very clear. Any other member wishing to speak? If not, Mr. Lang Kwok Hong. Well, please be brief, 4 minutes. No one is monitoring the government these days, except for Mrs. Regina Yip, because she is going to be the next chief executive. She is the real opposition. I went back to my office just now, but I heard what you said. My first question. We think that the futures market is too small. We want to stimulate its development, hence the proposal on the latest regime. The Hong Kong X is a listed company, right? That's confirmed. The listed company would like to boost its business and would like to earn more money. How does SFC monitor its performance? SFC is not listed. Is not a listed company. The Hong Kong Exchange is itself a company, and it has a certain vested interest. If it comes up with more products and sell more of its products, then it can earn a bigger profit. On top of this, the senior management will get a share of the profit, right? So the Hong Kong X senior management will get some benefit if the performance of the company is good, right? Is that right? Can SFC give me an answer first? Internationally, except for the exchanges in a small number of countries, many exchanges are really listed companies. It's say Singapore, Australia. This is the case. It is a profit-earning commercial entity. In monitoring these companies, SFC will have regard to the bigger picture of in Hong Kong. We would not take the perspective of how much it will earn as its profits. You have different principles, right? Well, they are the thief, and you are the one to catch the thief. Maybe I'm a bit exaggerating in using such an example, but they do have the incentive to diversify their products. It's just like a casino. If they can boost their business, then they can earn a bigger profit. And the SFC is there to monitor the entire market. So my question is simple here. The chairman talked about position limit. You said that the futures market is too small now, so you think that people should be allowed to hold more positions. So do you have you assessed the risk of doing that? And also, have you compared yourself against other countries? We have Shanghai Stock Connect and Shenzhen Stock Connect. And how do these two perform in that regard? If we have a lenient policy, people will be attracted here. But if we tighten our policy, people will go away. So this is a simple principle. Everybody wants to earn a profit. Now, if we want, people may choose a more conservative approach, or so. How do we compare to, say, Singapore, Shenzhen, Shanghai, our main competitors? Have you conducted a study on how they fare? Mr. Loy, a simple answer, please. In an active stock exchange, for example, US and Germany, the futures market will be tying in with the stock market because they can serve a hedging purpose. And it's also speculative, right? People will become speculative, and yes, risk assessment is part of our work. And if we increase the position limit, Mr. Lang Kwok Hong, please don't barge in. Allow Mr. Loy to speak first. You've gone over time already. I will not ask any further. Nobody is here to ask any question. We still have one more item. Next one, Mr. Holden Chow. Thank you, Chairman. Long hair speaks with sense. We are increasing the position limit, the excess position limit. The administration said that these are for the purpose of hedging. Now, increasing 50% to 300% in terms of the excess position limit, there will be further risk. But we do that. I note in your paper that they should have, the holding company should have a net asset value of not less than $2 billion, but that will be increased to $5 billion. Do you think that's adequate? Have you taken reference from practices in other jurisdictions? Now, the position limit will be increased from 50% to 300%, and that's quite a substantial increase. But then, $2 billion, $5 billion is just more than doubled of the original amount. So do you think that that's sufficient, and how is the situation like in other countries? Mr. Loy. Many major financial organizations are dealing in OTC derivatives. They are not doing it as a form of exchange traded contracts. But then for the OTC market, the transparency is lower, the monitoring is poorer. So one of our objectives in this regime is to attract these OTC market activities back to the exchange market so that the SFC can have a clearer picture of how the risk situation is like and adopt corresponding measures to control risk. So this is a practice also internationally, not just Hong Kong, attracting OTC market activities back to the exchange market. Now, concerning the $2 billion to $5 billion increase, if we increase the excess position limit, at the same time we want the net asset value of these financial organizations to be even higher. So the higher the asset value, the more the resources they have, and they are in better position to do risk management as well. So we will look at the organizations individually. Well, for many multinational corporations, they normally have a net asset value of more than $5 billion. Can I have a follow-up? Do we have sufficient time? So the time is tight. If we have a second round, it's just 2 minutes for you. We understand the administration's explanation, but then my question is $5 billion enough? How did you come up with that? Now, if many companies have an asset value higher than that, why don't you raise it even further? I'm worried about the risk. Mr. Lloyd. Well, the original amount was $2 billion, and in the listing regulations, that was a set and then has been adopted for a number of years. So that was a starting point or threshold adopted way back. Now, after so many years, we think it's just right that we should at least double and then bring it up to $5 billion. Second round, 2 minutes, Mr. Lang Kwok Hong. OTC market, that's a trend. In face of globalization, of course, and we're now attracting it back to the exchange market. I think that's wrong. If we have a big exchange market, then we also have a big OTC market. Well, that's the OTC market is really for hedging. Well, to me, it's the risk seems to be even higher. I know that these are 5 stones, say here, and then if they are outside of the room, then they will become 500 stones. I really don't agree with your logic. I don't think the SFC can supervise them. If there is another financial tsunami in the future, and if I still remain as a legislator, then I'm afraid that there will be another Lehman Brothers incident. In 2003, they wrote to us. Would you allow time for Mr. Lloyd to answer? Well, in 2003, they wrote in to say that these OTC derivatives were very problematic. I think we're just going down a similar route. I don't think what I said will please you, but anyway, I'd don't accept what you say, we're not preventing any risk here. Well, your time's up. If no other member wishes to speak on this subject, then I would also like to say something myself. The derivatives market in Hong Kong is getting bigger, and many of them are being traded OTC. And actually the transaction volumes is even higher there than within the market, because there is a limit on the position.
So the government is proposing to raise the cap of the prescribed position limits to absorb the transactions originally in the OTC market. I think it's conducive to risk management. And I think the SFC's proposal can also facilitate the overall financial development. And Mr. Olden Chow just now expressed his concern on raising the cap from 50 to 300%, whilst at the same time the net asset value requirement would only be raised, or financial adequate capability requirement would only be raised from $2 to $5 billion, and it's out of proportion. I think that the risk has already been reduced by allowing a higher position limit. My concern is this. If one is to apply to the SFC for the excess position limit, I wonder how long it would take. At present, it takes 6 to 8 weeks. I think it's too long because the market keeps evolving. If we wait too long, the opportunity of holding a higher position may be lost. So I want to make sure that the application or the time for processing the application can be shortened. Chairman, in vetting the application, we consider the risk management and compliance of the company. We look at the compliance culture. So the first application may take a longer time. If subsequent applications are made, albeit on different areas, then since they have the same set of risk management procedures, the time needed for processing the application will be shorter. If there are no other comments, then that's the end of this item. Thank you. We have another item to discuss, so I think we should extend the meeting to 10:40. Any objection? If not, then we can now discuss the next item under any other business. I received a letter from Mrs. Regina Ip dated the 9th of December requesting that our panel invites the government officials set out in a paper, set out in her letter, to discuss the consultation on the proposed enhancement to the Stock Exchange of Hong Kong Limited's decision-making governance structure for listing regulation. Mrs. Regina Yip already asked a question, oral question in the Council, and the relevant proposal was endorsed in the end of November. And with Deputy Chairman, we discussed with the President on the work of the panel, and we touched on this issue. We understand that the Hong Kong Stock Exchange will need to analyze the views received and to devise the way forward. And I understand that this item would be put on the items for discussion list and will be discussed in April next year. I'm also concerned about the industry's concerns on this matter, so I'd like to ask members' comments how we should follow up on this. Should we convene a meeting in April or before that, or even before Chinese New Year? I'd like to seek members' comments on whether a special meeting is needed. Mrs. Regina Ip. Well, you understand that a lot of members would be on leave during Christmas, and I think April would be too late. So I suggest we have a special meeting around Chinese New Year. Chinese New Year or New Year? Before Chinese New Year. Because, Chairman, as you know, you moved the motion debate in the council, and a lot of members spoke, and the 3 professors from the Asian Institute of International Financial Law also suggested that the LRC's recommendations are ultra vires, because one must act in accordance with the law. There we have independence and transparency. And if we have the new LRC, then it's 3-3. We're not dealing with only deceptive stocks, but also other problems without monitoring. And according to these professors, this is ultra vires. So it is very important. We must advance the discussion of this item. We have already set our agenda items. So if you have any ad hoc item, the only alternative is to call for a special meeting. Deputy Chairman, your view? Chairman, I of course understand Mrs. Ip's concern, because among professionals, among industry practitioners, and among companies, views are divergent, and this is a controversial issue. We understand that we have already set a very tight schedule for the panel on financial affairs discussion of items. And I think in principle we can have a special meeting around Chinese New Year, but we should consult views of members in writing first. So it may be possible that we can't hold a meeting until April, Mrs. Ip, but at least I think we should write to members and seek their views as soon as possible. Do you agree? Mrs. Ip, agree, support, thank you. So let's take on Deputy Chairman's suggestion, and I will liaise with the Secretariat to do that. Members will be informed after a date has been set. Thank you.